Okay. Good morning, everyone. My name is Akila Robinson, Vice President of SSU's Davis Campus. And today we will be having our info session led by our very own law consultant, Mr. Bill Reid. Before we get into it, I would like to welcome everyone here today, and I trust everyone had a great weekend. With that being said, before we hop right into things, I would like to take a moment to introduce our speaker. So next. Okay, so our presenter today is our very own SSU legal consultant, no other than the wonderful Bill Reid. He provides legal advice to Sheridan students free of charge as it regards to landlord and tenancy issues, immigration, business, criminal law, etc., etc. Today, he will be focusing on criminal law and giving us some basic knowledge in regards to that aspect. So I will now hand over the mic to him and he will lead us out today. Go right ahead.
Thank you, Akira.
You're welcome.
So, yes, we are talking about some aspects of criminal law today, and make the point, I think I'll make at the end as well, but I'm going to be talking about a few things. I don't expect anybody to remember everything I say, but I do hope to be able to flag issues that people will think about as they live their day-to-day lives, especially if they cross paths with police. And maybe the most important things that we convey today are that we as the student union exist, and I as a lawyer, a real lawyer, exist, and will provide my email address later on as well, because, yeah, I'm here to kind of discuss some issues so there's a greater awareness, but overall, the most important thing to keep in mind is that I'm available to be reached out to in any kind of situation. I don't expect you to remember everything I've said, just remember that, like I said, that I exist. So first of all, we're going to talk about what happens if you are approached by the police. And I'm not sure now who's maneuvering this. There we go. Perfect. Nice segue. So the only time that most people have to identify themselves to the police is if they are driving. And if you are driving, the police do have the right to instruct you to pull over. In fact, if you have the care and control of a vehicle on a public road, the police have the right to require that you provide identification and that you show not only ID, but a driver's license in particular, your own and current, and proof of ownership of the vehicle. It doesn't have to be you who owns it, but proof as to who owns it, and proof that it is insured for use on the highway. So the police do have the right, if you are driving or you have the care and control of a vehicle on a public road, they do have the right to approach you and to require that you cooperate with them to those respects. They also have the right to require that you take a roadside breathalyzer test. And but that is all in that situation of driving. If you are just walking along a public sidewalk or a public area such as a park, there is not an obligation to engage in a conversation with the police if they approach and they ask you to. There is not an obligation to speak to them. There is not an obligation to answer questions. You have the right to say politely, you wouldn't say it in any aggressive manner, but you have the right to say politely that I don't wish to speak with you. I'd like to move on. Have a good day. Goodbye. If the police do insist on speaking to you, then they are essentially detaining you, and you have certain rights, one of which is to know why you're being detained, because it comes back to the police have the right to charge someone with an offense. They have the right to arrest someone if the charge is serious enough, but they either have to do those things or let you move on. They do not have the right to detain you and insist on talking to you, and at the same time not arrest or charge you. They need to make that decision. If they feel they have the grounds to charge you with something, if they feel they have the grounds to arrest you and take you down to the station, well, they may do those things. But if they don't do those things, you can say, I don't wish to talk to you. You don't have the right to detain me, and I'm leaving. So that's an important distinction to keep in mind, that you do not have the obligation just to talk to police because they ask you to, or certainly to answer any questions. If they do charge you with an offense, in certain offenses, they can charge you with without actually arresting you. Simple offenses, like I'll say minor offenses. Or if they arrest you and say you must come with us and we're going to charge you, then in either of those situations, it is still wisest to remain silent. In those situations, if the police do those things, which they have the right to do, it doesn't mean that you're going to be found guilty, but they're not, all they're doing is laying the charge. They don't have the right to enter a conviction against you. That's the eventual court system. The police only have the right to charge and possibly arrest. If they do that, that's fine, you must not resist, but still do not enter into a conversation with them, because they will have the right to record any conversation that you have with them, any statement that you make. And the police will, if they arrest and charge, they will provide documentation that includes a court date, and just take that and leave. Don't attempt to explain yourself further to the police. You'll have that chance to do so in court. Akira, was it you who had a question? Yeah, go ahead.
Yes, I do. Okay, so on the grounds in which you were detained and arrested, but they did not charge you, how long can they have you in prison for? What's the minimum to maximum?
Well, they have to have a bail hearing within 24 hours.
Within 24 hours.
But that's if they charge you and they don't release you. They really do not have the right. They really would not arrest without charging. The only grounds they have to arrest is to charge. And like I say, they can charge without arresting if it's a simple thing. And I talk about simple things like having open liquor and alcohol, open alcohol in public.
Yeah.
Things like minor trespass, if you are on private property and you don't leave when you're asked to.
Right.
Little things like that, or that kind of thing, they would not normally arrest, but they can lay the charge. Those are for the most part not criminal offenses, but just provincial offenses. The same with highway traffic offenses, like speeding. They do not actually arrest you, but they can charge you at the roadside.
Yeah, part one. Yes.
And certain offenses related to driving turn out to be criminal. They do sometimes arrest someone at the roadside and have to have the car towed.
Yeah.
But they can also just lay charges. But to arrest and hold you without charging, no, they don't have the right to do that. Okay. I think where you're maybe going with the question is if they arrest and charge, but then don't release. And because for most charges, even that they do arrest, criminal offenses, relatively minor ones such as assault, theft under $5,000, fraud under $5,000, they will arrest and charge and then release with that court date.
Okay.
That's when you come back. For a more serious offense, yes, they may hold the individual in custody, but they have to have a bail hearing at which a justice of the peace decides whether the person goes free or on what terms, such as bail, or other terms, including having to live with a surety, another individual, things like that. The justice of the peace decides those terms, and the bail hearing must be held within 24 hours.
Okay.
Okay?
Thank you. Yes, thank you so much.
So, yeah, so like I said, the police, anytime when, either way, whether the person is held in custody or released, the they'll receive documentation, including a first court date. So then we can move on. Thank you. Pardon me, sorry. We can go on to the next slide. So if you are charged with a criminal offense, you will likely be released. And what I say is because it is only the more serious ones that they would hold someone in custody for. But based upon a promise to appear in court on a specific subsequent date and time. Now, people sometimes get that documentation and they have the court date. They see the court date and they think that is their trial. That is not the trial. That is what is called a first appearance, and that's all that it is. And I believe the next slide talks more about first appearances. So on that first appearance, the only things that will happen, really, will be that the Crown will provide disclosure, which is the Crown's case in documents and discs, and the next date will be set. And that's all that happens. Prior to the COVID pandemic and the shutdown and all, people who went in for a first appearance found that there were a lot of people there, and it's because the first appearances are so brief. They do schedule a lot on the same day. Now, some of the adjournments have been taking place automatically during the court shutdown, and some of them remotely. Like when I say automatically, meaning without having to appear, or in some cases appearing remotely. The court system has been trying to stumble along and keep things moving. But in any event, a first appearance is brief, and there are usually a lot of people scheduled, whether one way or another, on the same first appearance date. So again, all you do is get the disclosure and set your next date. You're out of there. If it is an in-person attendance, you may sit and wait for a while, along with lots of other people. But then once your name is called, you're out in like 60 seconds after that. Now, so I mentioned about disclosure because the Crown has an obligation to disclose its case in written form, and that used to be a stack of documents. But over the past 10 years or so, 10, 15 years or so, it's become mainly on discs. So just a very few documents and 1 or 2 discs, sometimes more than 2. But that is what the Crown has an obligation to provide. And usually you get that on the first appearance. If the Crown doesn't have it ready yet, then the Crown has to ask for an adjournment, and that's fine. They may do so at least one time. They just have to explain to the court why they don't have disclosure ready yet, and there can be valid reasons. The officer has been busy, whatever, or on vacation, but, or it may be in some cases a complicated case. And if it's a complicated case, then disclosure may not come all at once either. The Crown may provide what disclosure they have on the first appearance, and they may provide further disclosure at a later date, and they're allowed to do that too, as long as they do provide all disclosure before the accused is expected to make a decision as to how they're going to plead and enter a plea of guilty or not guilty, more often initially not guilty. The Crown does have to provide all the documentation before the accused is expected to do that. And then it's only after disclosure has been provided that an accused or a lawyer on behalf of an accused can negotiate with the Crown. But we certainly do that for students who are charged with offenses. And in some cases, it's possible to negotiate that a charge be withdrawn. And that happens when we're able to show the Crown that there are a lot of facts that they weren't aware of, and the Crown takes a look at it, maybe has the officer investigate further, and comes back and realizes that when they see the big picture, they don't really have a reasonable prospect of achieving a conviction against that individual in court. So there are times when we can have cases just withdrawn, no terms. Obviously, that's only if all other circumstances call for that. There are many situations in which we can have a charge withdrawn, but on terms. And assault cases, for example, I have assisted students to accept anger management or other counseling, alcohol counseling, drug counseling, psychological counseling, or to make restitution, for instance, if they shoplifted or if they committed like minor vandalism and damaged or broke something or whatever. And so I have been able to achieve withdrawal sometimes, but on those terms. Withdrawal on the basis of attending counseling, withdrawal on the basis of paying restitution, paying for what was damaged or destroyed or stolen. And in some of those cases, or maybe in some cases, a combination of those elements. And we then have the case withdrawn. But again, anytime it's withdrawn, even on terms like that, what that means is that the student does not ever need to actually plead guilty and be found guilty in court. There are also times when they may have to take the step of pleading guilty and a conviction being entered, but then the conviction being discharged, again on terms. And in more serious cases where the Crown and perhaps the court are not willing to accept withdrawal on the basis of the things that the student can do, but they may require those things for the student to do and enter a guilty plea, have the conviction entered, but then discharged, so that all that the student ends up with is what is called a conditional discharge. The benefit to that is still better than a conviction, because a conviction stays on a criminal record, and the only way it is ever gotten rid of is by applying for record suspension. It used to be called a pardon, it's now called record suspension, and that you have to wait a certain number of years depending on the severity of the offense and go through a whole application process. With a conditional discharge, that shows up on a criminal record, but it shows up as a conditional discharge, not as a conviction. So anyone who has to see the criminal record sees that it is a discharge and not a conviction, and a conditional discharge is removed from our criminal record automatically after 3 years without any obligation to wait longer or go through the application process. So again, if the situation is serious enough that the Crown will not simply withdraw, even in exchange for things that the student may do, if they agree to accept a conditional discharge, and then the student pleads guilty and only has a conditional discharge, that in turn is still much better than the actual conviction. And we can move on. Oh, is that okay? Well, that is the essence of what we wanted to talk about today. And as I also said, though, so this is the online form to make appointments. And we also have a slide, I believe, that has my email address somewhere, right?
Yes, we'll pop that in the chat for students.
Perfect. Okay, thank you. Because, like I said, we are simply intending to flag issues today to raise awareness that these issues exist, but mainly to raise awareness that the student union exists and that I am a part of the student union and available to help with these kinds of issues. And so to be mindful not to try to remember everything I said, but to at least remember that I am accessible and that every situation is, of course, different, but we can talk about the situation and in every individual situation, look for the best way out of it.
Precisely. Okay, thank you so much, Bill. Is it me or is it myself?
No, it's all good. Thank you. Okay. You're very welcome. I just didn't want to interrupt.
Okay, great. Does anyone have any question to ask Mr. Reid here today? I myself do have one, but I would like if someone would go before me.
Well, sometimes also people sometimes would rather discuss privately rather than, orally this way. And that is why that's entirely great anytime at all. And there's the email address. Madison has put up my email address, w.a.reid@gmail.com. There it is.
Thank you, Madison.
Yeah, thank you. And I am in touch with that every day. And so don't hesitate to use it.
Okay.
In the meantime, Akila, you did have a question you wanted to talk about, so let's talk about that.
Okay. It's nothing to really go deep into. I was just trying to remember because I take a paralegal course here at Sheridan, and I was trying to remember the specific legal term for your promise to appear in a court on a specific day or time. Is there a specific legal term for that? I think there is.
Well, that's the first appearance.
Oh, that's what it's called. Okay.
Yes. And that is what is the first appearance. And the interesting thing then is that you may make more than one such appearance.
Okay.
And you won't know all the people who are there. Like I say, there's a lot of people, and whether it's done in person or remotely or just what. They're all making appearances. In some cases, it's their first appearance. In other cases, it's not the first, but it might as well be because it's the same structure. The issue being that has disclosure been provided? Maybe there's some more. Maybe it already has. Maybe how many times has it been up, as they say? What is the reason why it's back in court this time? But there can be valid reasons. Now, I talked before about efforts that we sometimes make to have charges withdrawn or to negotiate appropriate resolutions. And one of the things I mentioned is that the accused may have additional information that they want the Crown to consider. And very often that may be other witnesses or other things that the police officer in charge has to investigate. So the Crown, it's not their job to do everything with that additional information that the accused provides. They will more often say, okay, thank you. They will instruct the officer in charge to investigate further and then come back to the Crown with what information they obtain so that the Crown can make a further decision. And so all of that can take time. So a first appearance, a matter, if disclosure is provided, a matter is usually adjourned for about 3 weeks. And that gives the accused or the accused lawyer a chance to have a pretrial with the Crown. That cannot be done until disclosure is provided, but once disclosure is provided, and I do that by telephone, as most lawyers do, telephone or email now. And so if it's a situation where perhaps I say to the Crown, there are more witnesses, there's other evidence, the Crown says, okay, we'll instruct the officer in charge to investigate further. Well, that's going to take longer than 3 weeks, and sometimes a lot longer. And so the Crown and the accused, or the accused lawyer, will agree that the matter should be adjourned on the basis that pretrial discussions are ongoing. And the hope is that we'll come to that resolution that will be satisfactory to all parties, but the pretrial discussions are ongoing. So on the actual court date then, either the accused or more often the Crown will say, Your Honor, in this matter, pretrial discussions are ongoing, so we would like to request a further adjournment of 3 weeks or sometimes a different length of time. And the accused, of course, agrees, and the judge says, fine. As long as you can both tell me that pretrial discussions are ongoing, I'd rather hear eventually that the case has been settled rather than having to be a trial or other procedures to take more of the court's time. So great, if pretrial discussions are ongoing, both parties agree, it's only been a couple of times that that's been said in court, great. Adjournment granted, next case. So that is, when I talk about that first appearance court, as people making appearances, it's not always their first, but the structure is the same, and sometimes there can be 2 or 3, and that is one of the main reasons, is because pre-trial discussions are ongoing, and the officer is investigating. Eventually, ideally, if the parties can come to terms, can come to an agreement as to a resolution, such as entering into counseling or making restitution, and whether it be a withdrawal or a conditional discharge, and sometimes it's obvious that that's all that the Crown will agree to and all that the court would agree to as well, the judge, then that is what is called a joint submission, because the Crown and the accused go in and they're on the same page. They're in agreement as to what to ask of the judge. And if it's just like I say, where the judge is asked by both parties for an adjournment on the basis that pretrial discussions are ongoing, if the judge is asked by both parties that the accused do counseling and then there be a withdrawal, great. If the judge is asked by both parties that the accused is going to plead guilty, but then they're going to ask the judge for a conditional discharge and such conditions. In all those cases where we've been able to achieve agreement between the Crown and the accused, and there is a joint submission to the judge, invariably the judge will agree with that, because they want to have cases resolved efficiently as well and move on to other cases and get done their day. So that is often how cases are eventually resolved. It's only the minority of cases that have to go to trial. And if that is the case, we certainly make every effort to avoid that. But if that is the case, then we deal with that as a separate eventual matter. But so many cases can be resolved without the need for a trial through the negotiation and agreement process.
Okay. So for the most part, the burden of proof in criminal law would be on the Crown.
Correct.
Okay.
However, where it's obvious that evidence exists that the accused did something,
Yes.
well, we may be able to negotiate a fairer view of what actually happened, and therefore a more lenient resolution that may be more appropriate in view of the big picture.
Okay. Okay. That was a lot to take in today. Thank you so much.
Oh, you're very welcome.
Okay, folks. Okay, so we have came to the end of today's criminal law info session. Once again, thank you so much, Mr. Reid, for your knowledge and for having this time, taking the time out of your busy schedule to share this information with us today.
Thank you, Akira.
Yes, and
thank you. Yeah, no, go ahead.
Okay, and I hope that the knowledge that he shared with us today will be used in our everyday lives, hopefully, but that we don't get stopped by the cops for sure. With that being said, guys, please be aware that you can once again contact Mr. Reid by going on our SSU page and booking an appointment to speak with him, either email, which is it is in the chat, folks, w.a.reid@gmail.com. Also, for all our other services offered by the SSU, simply head over to our page and find what you will need. With that being said, folks, please have a great day and stay safe
you, Akira.
through this pandemic.
Yes.
Thank
all
you.
Right.